first, of course, you had the Supreme Court revoke women's constitutional privacy rights. Then you have them saying to our African-American brothers and sisters, it really doesn't matter your history. It doesn't matter that you were, brought here as slaves. It doesn't matter that you were not permitted to accumulate property or wealth or pass it on to your children so your future generations could begin to catch up. It doesn't matter that all public accommodations were separate but equal until 1954. And we all know damn well they weren't equal, and they frankly still aren't. It doesn't matter that you, to this day, suffer all of the consequences of the kind of deeply entrenched systemic racism here in America. What you're going to have to do now is you're going to have to compete on a level playing field with all of the other populations who had absolutely none of those adversities in their history. So have fun with that, friends. That's disgusting. It's despicable. Frankly, it is the Supreme Court cementing racism and the effects of racism into American society. So that is my continued thought on that. With respect to the LGBTQ plus ruling, plain and simple, here's what the Supreme Court has done. They have said, if you cloak your prejudice, your racism, or not your racism, your intolerance and your hatred of others, if you cloak it in religion or freedom of artistic expression, you can discriminate against anyone you damn well please. That's what the Supreme Court has announced. They are sending our nation down the toilet. The silver lining, though, Jody, is you think we were motivated to vote in November of 2020.
Exactly.
You ain't seen nothing yet.
Glenn, I've had a lot of friends of mine after the website ruling say, okay, the Supreme Court says that we can discriminate even if you're a protected class. So I can if you walk into my business as an evangelical Christian, I can refuse business to you.
Yeah.
Is that true?
Yeah, so that is an eye for an eye approach, and everybody goes blind. Here's the problem with that, Chris. First of all, you're dead right. You and I and Jody and everybody else can now discriminate if we claim it's religious-based discrimination or artistic expression-based discrimination. But what do we do if we do that? We are legitimizing the court decision that says this is an okay thing to do. I'm not going to do that. I'm going to fight against this court decision with my vote and with every other tool that we have in our toolbox.
Okay. Yeah, I just asked that because I wanted to know if what these what my friends of mine were saying were true or not. And I guess
it sounds
is true,
legal, yeah.
But it's just not good practice.
No, it's dumb business.
Yeah.
It's dumb business. Now, with that particular case, since it was a hypothetical, is there a way for that to go bye-bye?
Well, the good news is there is, Jody. There's what's called a petition for reconsideration. I believe the Supreme Court rules give the litigant 45 days from the time of the opinion to petition for reconsideration. I have to believe I guess it's the Attorney General for the state of Colorado is drafting that petition for reconsideration as we speak because it was a made up case. The Constitution requires a case or controversy. There was no case and there was no controversy. So let's hope the Attorney General for Colorado petitions for reconsideration.
Let's do that for sure. Now, it looks like the guy that was threatening the Obamas is going to be released.
It sounds like it. Yeah.
It just seems, I mean, I don't know the law, I guess.
After, I guess, Trump published his address?
Yeah, Donald Trump published Obama's address, doxed him, and this guy went to the House and then surrendered. But why do you think they might release him? Is it because it's his first offense? I mean.
So here's the thing. There is a standard for detaining somebody pending trial, and it is that person is either a danger to the community or is a flight risk. And the prosecutors have to prove that in court by clear and convincing evidence. That's a much higher standard than probable cause to arrest. It's obviously a lower standard than proof beyond a reasonable doubt to convict, but it's a pretty high evidentiary standard. I've had to prove it hundreds of times. So I assume, and I am now learning from you all, thank you for breaking the news to me, that this guy Taylor Taranto is apparently going to be released. I assume the judge decided there wasn't clear and convincing evidence that he posed a danger to others.
Okay.
I don't know how that can be when Donald Trump posts his address. This guy reposts it on his social media, arms himself with 2 guns, 400 rounds of ammunition, a machete, and then heads to Obama's home to get after him. I don't understand how he is not a danger to others. But here's the thing. If the trial judge, the first judge to make this decision, got it wrong, then the prosecutors can appeal it, and hopefully they will. And hopefully this guy, who's an insurrectionist, mind you, at the time he was wanted for his crimes on January 6th at the U.S. Capitol. This is a guy that should be detained, at least based on what I've seen publicly reported.
And what they're saying is he might be released before trial unless prosecutors bring more serious charges against him in the next week. He brought weapons to an ex-president's home. That to me is dangerous. I don't see Judge Zia Faruqi.
Zia Faruqi. I know Judge Faruqi well. I used to work with him. And here's what will happen. I predict that the prosecutors will very quickly bring a superseding indictment with more charges if the evidence supports it, or they will appeal. So Judge Faruqi is not a full judge. He's a magistrate judge, and it can be appealed to a full judge. So I have a feeling that's what we may see next.
Because apparently right now...
And let me add, Jody, Judge Faruqi, not just because I know him personally, he is an excellent jurist. So I will have to scrutinize his opinion to see why he reached that conclusion.
He hasn't quite reached it, according to this reporting. Basically, the problem is so far... Toronto is only being charged with misdemeanors, and that's, I think, why the judge is saying, well, if it's only misdemeanors, I got no choice, correct?